against the second state of the Home Department of Northern Ireland.
Mr. Mulholland.
Thank you, my Lord.
Yesterday, I think you started about 25 minutes earlier than timetable, so by my calculations, you've got till about 12:35.
Well, in the ease of the court, famous last words, as the Lady Chief Justice will no doubt tell you, I hope to be under an hour this morning. And yesterday, whilst we addressed the issues around the statutory duty upon the Home Office, the Court of Appeal in Northern Ireland's concerns about putting the burden onto the first-tier tribunal and the individual applicant, this morning, in 5 points in short order, which I perhaps set out, first of all, I hope to bring the court through, and optimistically, if nothing else, as I say,
thank you very much.
Our submissions within the hour, my Lord, would be our aspiration.
I see an obstacle in the path of that aspiration immediately. Could I just raise with you a matter on which you were addressing us yesterday afternoon, and that is the power of the tribunal to remit a matter to the Secretary of State. Am I right in understanding that it is your case that there is a power in the tribunal to remit to the Secretary of State, and that is what's referred to in paragraph 40 of your written case?
That's the clarification, my Lord, I wish to draw the Court's attention to yesterday.
I'd be grateful. Thank you.
That answers the question. Sorry,
what was the question? What was the answer?
There is no direct power.
No direct.
So it really is the paragraph 38 of the MK decision, in which the suggestion being that one pragmatic approach to this is almost a remittal by proxy, that by the use of the court's powers before the tribunal's powers at first instance, that would achieve the desired objective.
It's paragraph 38 of MK.
Indeed, my Lord, yes.
Thank you.
So this morning, the 5 points in short order, if I may, I'll just simply outline. The first is the principle of anxious scrutiny in the context of Section 55. The second is the suggested application of the guidance in the context of Arturis. The third point is the relationship between Section 55 and Article 8 of the Convention. The fourth is the issue of the application of Section 55(3) in circumstances when in a judicial review form as opposed to the first-tier tribunal. And then finally, whilst not part of the appellant's written submissions, Mr. McGleenan made express reference yesterday to this concept of regard and or due regard. And we've tried to take a look at that overnight. I'm limited in what I would say on that today, but certainly I feel it's important that I should, in some brief terms even, at least touch upon that, if that is of assistance to the court. Anxious scrutiny. In short form, if I could invite the court, please, to open the authority. It's found at page 1372. And this is a decision of YH 353 fresh claim case. The facts of which, whilst not directly relevant, nonetheless perhaps in short form can be summarised in paragraph 26. YH, being a citizen of the northern region of Iraq controlled by the Kurdish government, arrived in the United Kingdom claiming fear of ill treatment over the sale of a mummy, of all things, a claim that was originally found to be quote-unquote incredible. He then voluntarily left the United Kingdom when his claim was declined, with the assistance of financial scheme provided through the government, and then he illegally returned. And as Lord Carnwath observes at paragraph 42, if I may open that briefly to the court, that the accounts and the variety of accounts given by YH were such.
We're on page.
I'm sorry, my Lord, it's page 1385, paragraph 42.
5.
Under the subheading discussion.
Got it, thank you.
And the first sentence, perhaps, of that paragraph sums up the perspective of the court. The problem with YH's story is not merely that of inconsistency, but of inconsistent inconsistencies. And that was the backdrop in the course of the consideration of a number of principles that the court felt it appropriate in the course of this decision to consider. And for present purposes, at page 1379, subparagraph, it's under the subheading anxious scrutiny, sub-Roman numeral 5, paragraph 22 sets out the expression of anxious scrutiny derives from the speech of Lord Bridge in Bugdagde against the Secretary of State, in which he said, quote, "The most fundamental of all human rights is the individual's right to life, and when an administrative decision under challenge is said to be one which may put the applicant's life at risk, the basis of the decision must surely call for the most anxious scrutiny." At paragraph 23, that theme is taken up in this context. It has since gained a formulaic significance, extending generally to asylum and Article 3 claims, citing MacDonald at paragraph 8.6 and the case WM, Democratic Republic of Congo, where Lord Justice Buxton explained that where asylum was an issue, the consideration of all the decision makers, the Secretary of State, the adjudicator and the court, must be informed by the anxious scrutiny of the material that is axiomatic in decisions that, if made incorrectly, may lead to the applicant's exposure to persecution. And respectfully, my lords, ladies, it's the emphasis on the consideration of all three that we respectfully submit has a bearing in this case, in the circumstances where, when one speaks of the expectation before the decision maker and, of course, before the court at first instance, the thrust of that is that there will be anxious scrutiny brought to bear in the context of the consideration of 55.1 through the prism of 55.3 and the guidance. And the Lady Chief Justice yesterday, my lady, made reference at a point to the guidance in the context of evidence gathering. And respectfully, we would submit the thrust of our tourists is very much heading in the other direction in terms of the responsibilities on the Home Office and placing those as the extension of the decision-making process onto the tribunal itself. And it is perhaps the angst of the Northern Ireland Appellate Court decisions in both JG and CAO. It's the consideration of this principle of anxious scrutiny. I may be wrong, but certainly I don't believe it's referenced in the Arturis decision. That certainly has given rise to the observations by the Appellate Court, where in essence, if anxious scrutiny is and should be facilitated at every stage, and even though it may be the opportunity arises in many instances but not all, or in some instances and not many, depending upon how one looks upon it, that the FTT can perhaps cure the omissions. But it poses the question, well, in those circumstances, what is the incentive for the Home Office officials to comply with their statutory obligations if there are no consequences for failing to do so? And it is in the CAO decision, perhaps most aptly summed up, if I may very briefly open that. I believe now the court has, it's a paragraph 75 in the revised judgment. It was the original 76. Just to ensure that it's the 76 as I have it, your 75, so I assume begins with the sentence "for the reasons elaborated above."
No, it's now 76, I think.
I'm grateful, my lady.
It's now 76, is
Now
it?
76. For the reasons elaborated above, This court does not agree with the upper tribunal's assessment of the content of the statutory guidance. I should say this is in the context of considering the Atturis decision. Independently, this court expresses concern that in Atturis there is disproportionate emphasis on the south side of the notional bright line, namely the content of the guidance at the expense of its north side, namely the solemn and unqualified statutory obligations of UKBA officials to have regard to the guidance in every case where this is required. The decision in Atturis does nothing to encourage compliance by the Secretary of State and UKBA with their statutory duty to children. It is, rather, to the opposite effect. The persistent failure of UKBA to discharge this duty has been exposed judicially over a period of years and evidently continues unabated. This is a self-evidently disturbing state of affairs, and it's those observations in the context of this duty and in the context of the Home Office, we say, being best placed to undertake the task to comply with the duties, having the framework in place, the training of staff, and of course the obligations that we say arise in the discharge of those functions, which is consistent with the Court of Appeal approach as elucidated within CAO. And whilst Mr McLean makes reference yesterday that the mischief at the heart of this case really is the failure by the Home Office to cite express reference to 55.3, well, form over substance, the mischief really is that either there has been no consideration of 55.3, there is no evidence of 55.3 in cases being extrapolated in the decision letter, and perhaps most importantly, where there has been a derogation or a decision not to apply the guidance, then again, that is absent or lacking from the written decisions that emanate. So the court is left, therefore, at the first tier in a vacuum, absent that specific information, in order to try to ascertain what in fact was taken into consideration in accordance with the guidance, if anything, if the letter of decision fails to address one of those two obligations, either setting out what was, and if it was not being followed, the reasons why not, as required under paragraph 6 set out in the introduction of the guidance.
So can the first tier tribunal not in an inquisitorial way find out about any issues that are raised of concern in relation to the evidence by the appellant or by the questioning of witnesses? I mean, I think we need to know your position on this in terms of remedying any deficit, firstly.
The deficit is if I could perhaps, my lady, ask the court to turn to page 1170 of the CAO.
But just before you do, just that may be in general terms.
In general terms.
Can the FTT remedy what may be argued as a deficit, do you say?
In some cases, yes. It's quite fact sensitive. Excuse me. In some cases, yes. There's no doubt they can.
Right.
And the case management powers can be used to that end to great effect. Excuse me. But in other cases, no. And respectfully, whilst adopting an inquisitorial role, rhetorically, is the court to start to question the child who can be called to give evidence, to try to explore sensitive issues in a public forum? At the same time yesterday, Mr McLean was saying, well, it's maybe to the child's benefit that there was no interview here because it could have been very upsetting, it could have had an impact on the child, etc., etc. So it's the practical outworking in a court environment that could pose problems, number one. Number two, that of course requires that the Home Office play their part. And in this case, to play their part, they should at the very least turn up, which did not happen here. The Home Office were unrepresented. Number three, when one goes back to the structure and framework, and no doubt all tribunals at first tier and throughout, there is going to be a tension between resources, time, limitations on what, in fact, they feel they can actually do against a backdrop of sensitive cases such as this, where the Home Office, if complying with the legislative provisions, will have trained staff in place, will have a structure and policy guidelines in place, and in fact are best suited to undertake the inquisitorial role that is now being, in many ways, because of their failure to do so, foisted upon the court. So I know that's a very long-winded way, my lady, of answering that question, but it really is fact-sensitive, respectfully. And it is within that context that within CAO, it's citing at page 1170.
117.
So we're back to the main bundle.
I'm sorry, my lord.
We're back in the main bundle.
We're back in the main bundle at 1170, and the subparagraph is subparagraph 36, and again, this is extracted and set out from the MK decision.
Sorry, what is this we're looking at?
So this is an extract, my lord. It's within the judgment. It's paragraph 44 of the Court of Appeal, and this is an extract taken directly from MK Sierra Leone that is then set out and in ease of the court from page 1170. It's paragraph 36 of that judgment, MK judgment.
So it's 44 of CAO, and the
Yes.
Court of Appeal, citing MK Sierra Leone, paragraph 36.
Indeed, my lord, yes.
Right.
And the court in that instance sets out what they call, and it quotes, "In examining these issues, we consider it appropriate to reflect on the realities of the scenario of an appeal in which either the FTT or the upper tribunal decides that the impugned decision of the Secretary of State is unlawful by virtue of a failure to perform either or both of the duties imposed by Section 55 of the 2009 Act. The following are typically recurring scenarios in practice." And, excuse me, my lord, I won't read those out line by line, but we touched upon this yesterday in terms of the divergence of scenarios, some who are represented, some who are not represented, some in between. And of course, in instances where there is not one size fits all in terms of merely advancing, as the Home Office would suggest to this court, leave it candidly for the powers of the FTT to sort out and give us absolution from our statutory duty.
Can I say, I'm slightly puzzled by your answer to my lady's question when you say that the child, for instance, in this case, would need to be examined in open court. And if one goes back to the case management powers in the FTT rules that you showed us yesterday, Rule 4.3, the FTT can, at D, permit or require a party or another person to provide documents, information, evidence, or submissions.
Yes.
So I'm not following why it couldn't direct the Secretary of State and their staff to conduct an interview in appropriate circumstances, in private, and then provide evidence of that interview and what the child has said.
It could, my lord. And in fact, respectfully, I think we're at idiom on that point. That is the pragmatic outworking of the use of the FTT rules for that very purpose. But it's the fact that it has to arrive before the FTT, which in a sense becomes the first port of call, not the appellate structure, first point of appeal, where that is being done. So in other words, that is very much CIO's pragmatic and MK's pragmatic perspective post the barrier being put in place.
I thought MK's, as you put it, pragmatic perspective was a remittal by proxy.
That's our term. And by what I mean by referring it back to the Secretary of State from our perspective, respectively, would be the use of the rules, where it would be a Home Office member of staff, properly trained, familiar with the case, who would do precisely what my Lord has suggested.
Right. I have to say I didn't understand paragraph 38 of MK to be saying that.
The paragraph MK refers to the Secretary of State going back to first instance, as my
Yes,
recall.
the Secretary of State actually retaking the
Yes.
decision,
Yes.
whereas what
Yes.
you're envisaging here is taking
Yes.
evidence to help the FTT make the decision.
Precisely so.
Yes, but I suppose building upon that as a suggestion, what we're suggesting is with the use of the court powers at first instance, then, as my Lord Sales suggests, one of the directions that could be given, excuse me, is in fact that those on behalf of the Secretary of State should undertake the very functions that they were obligated to undertake in certain circumstances in the first instance.
Well, I'm sorry.
I'm sorry.
Well, I was just going to say that's not quite what I was putting to you. It wouldn't be somehow obligating them to do something that they should have done. It would be the tribunal asking them to compile evidence to assist the tribunal
Yes.
in its task.
Yes, it would be. I don't believe we're at any difference of opinion, my Lord, save for this.
All right.
That does require the proactive engagement of the Home Office, because again, from recollection, I believe in the MK decision, again, there was no appearance by the Home Office.
But
Now,
your
of course,
point-
that can all be remedied.
Your point is it would be better if they did all that before they took the initial decision, and then you might avoid the whole going to the FTT and the FTT having to direct them to do what you say they should have done in the first place.
Precisely, my lady, yes.
Right.
Is it to this process of using the powers to require the Secretary of State to interview the child that you refer as remittal by proxy?
Yes, it is, my Lord.
Right. Thank you.
So it is respectfully in our submission the practical outworking in the context of anxious scrutiny that does apply to the Home Office equally and clearly at all stages, that when one views the guidance in this instance, it is added to by the principle that we would pray an aid in YH. The second point is that of the interpretation of the guidance within our Arturus, and between paragraphs 30 to 31, Mr McLean has been through the case law. I'll not trouble the court with this, but between 30 and 31 in the paragraphs of our Arturus, it addresses the issue of the guidance, and it expressly addresses it in the context of the wishes and feelings of a child. But in fact, there is much more to the guidance than simply that. And when one reads the guidance in context, part one of the guidance, which was opened at some length yesterday, and the Lady Chief Justice, my lady, according to subject to the court, my note is that you may have made express reference, when Mr McLean did not, to, in the introduction, part one, page 1539, 1.4. Page 1539. So paragraph 1.4. Sorry, 1.14.
1.14, I think, yeah.
Yes.
And it was the first bullet point, whilst the third bullet point correctly deals with wishes and feelings. That is, in addition to the first bullet point, children and young people are listened to, and what they have to say is taken seriously and acted on. We find no reference to that in our tours. Within that context, again, the decision of this court in Zumbas was opened at some length yesterday. It's page 1519. And at page 1523, under the subheading just above paragraph 10, The legal framework was set out in some detail by Mr McGleenan in terms of the agreed legal principles. And certainly there is no issue taken between either of the parties in that case as to their correctness. Over page at 1524, there are 3 further principles from paragraphs 5 to 7 that were not open to the court that may have some resonance in the context of this case. Beginning at A, at page, sorry, my lord. This is page 1524 of Zumbas at paragraph A. At the,
Yes.
And reading into it, one will see in the second line, sub-paragraph 5, which commences, "It is important to have a clear idea of a child's circumstances and of what is in a child's best interests before one asks oneself whether those interests are outweighed by the force of other considerations." 6. To that end, there is no substitute for a careful examination of all relevant factors when the interests of a child are involved in an Article 8 assessment.
Just in relation to that, that doesn't mean that in every case you have to hear directly from a child.
I
I
respectfully
think what it means is you have to have a clear picture as to what the child's best interests are. And you may have cases where they're ad idem with a parent, or you may have cases where they're in conflict. So it doesn't automatically mean that you hear directly from the child.
I respectfully agree, Lady. Yes,
Yeah.
yes, I do. And it's the terminology of all relevant factors does not necessarily respectfully equate with, therefore, that necessitating or mandating the engagement directly with the child in each and every case.
Yeah, as I think as I had said yesterday, I mean, if there's a red flag in relation to
Yes.
a fracture potentially between a child and a parent, or a risk of trafficking, or a child who there's a query about the parental relationship,
Yes.
you would have to go down another route.
You would. And in this instance, perhaps paragraph 7 may be in point. Subparagraph 7, a child must not be blamed for matters for which he or she is not responsible, such as the conduct of a parent. And in this case, unfortunately, by reason of the fact that for the claims for the more recent years of domestic abuse not being believed, and or the risk of FGM on the part of the parent's account, then in fact the child's credibility was equally tainted, because the child not being spoken to, as we touched upon yesterday, the observations of Lady Hale, children can surprise us. There was a viable source of evidence, of information. It was a potential line of inquiry. It was a reasonable line of inquiry. But instead of that, the child in this case has been tainted by the observations and the assessment made of the mother through the eyes of both the UK border officials and also by the FTT.
Yes.
And really, our summation on that in one sentence is a child should not be disadvantaged if a parent is not believed.
I mean, in a sense, the child wasn't disadvantaged because the parents disbelieved. It's just that the case in relation to risk of FGM wasn't made out. The child didn't have a separate case.
We don't know, my lord, because in the more recent years of the domestic abuse, in the context of that factual narrative, there was reference, whilst the child was in her early teens, being moved to different schools, trying to evade the former husband, domestic violence still taking place. And if that was not being believed because of inconsistencies in the account of the mother, we do not know in that context, first of all, what else the child in her own perspective, could bring about her fear, her own genuine fear of returning, and the risk she may feel she was at the hands of her father, and then leading into whatever concerns she may be aware of around FGM. And it's the lacuna of that information. My Lord could well be right. It could simply be a situation where she would be wholly consistent with the mother. But it's the absence of the knowledge and making an informed decision in circumstances where it is the welfare of the child.
This seems to resolve back to a point that the tribunal should itself have sought corroboration of the evidence that it was being presented by the mother.
The term corroboration was used yesterday. If one wishes to call it corroboration, yes, but does that fall within either the ambit or the purpose of the guidance? There's nothing to say it cannot. Each case is fact-specific. But the terminology or phraseology, respectfully, I would suggest to the court is it's a source of fresh evidence, and it's a source of pure evidence coming from a child who is of sufficient years, of sufficient maturity, that can bring her own views, concerns, and fears that should form part and should be central to the decision-making process from first instance, i.e. before the Home Office officials in the first instance.
And are you saying the platform for taking that step is found in the facts in terms of the period? I think there's a period at boarding school that's mentioned, a period of being hidden away over, I think it's about 2 years at some stage. Is that the platform where you think the Home Office officials should have gone further to extract something more on the in terms of the history?
It is, my lady, yes. And it's in this context, one of the reasons provided contra the account provided by her mother was, well, she had known for several years of the father's aspiration that FGM would be performed, and yet did nothing about it. But over the time frame that this was first known about, the daughter was 3 years of age, and the age at which, in this instance, it was intended this would be performed was when she was 12. Similarly, it was suggested, well, even if, and Judge Grimes came to the view that, well, even if I did accept the account of the mother, relocation, protection from state bodies, so on and so forth, but outside of that is any consideration of how would that affect the child? How would the child, whether it's wishes and feelings, whether it's going beyond that into genuine concerns and fears, going back to a country, if she had witnessed a violent father, if she had witnessed a situation where she was aware of what his intentions were, bearing in mind the sisters, the 5 sisters of the former husband, had all themselves undergone FGM. We do not know in the environment in which this child was being brought up at the time that the marriage was, or the couple were together, what she had gleaned about any of this. No one does. But the unfortunate thing here is, in this case, no steps were ever taken to at least even consider finding out. And that, respectfully, we say, is the concern that when the case then reached the Court of Appeal, it was one of the live issues that troubled the appellate court.
But I mean, in terms of internal relocation and protection by the state, I mean, in essence, the evidence in relation to that was derived from objective country information.
It was, my lord, yes, it was.
I'm struggling to see how asking a 12-year-old child about those matters could gainsay whatever one drew from the objective country information.
The objective country, some of the information contained within the body of the documentation makes express reference, for example, to FGM at a percentage level of approximately, by 2016, I think it was, around 21%, and particularly in relation to Christian females, which she was, and in circumstances of this case where there was no dispute, it seemed taken, or no suggestion to the contrary, that other members of the extended family had had this procedure performed. And therefore, when dealing with the statistics and dealing with the considerations of relocation for that reason and purpose, those were the very type of things that the mother was explaining in the course of her interview to the authorities. Well, I did relocate, I did move, I took my child out of school to safeguard her, we moved somewhere else, we were going to move to another location, and because of the levels of crime we did not do so, etc., etc. It's the fact that once we have a level of a factual matrix, it's incomplete, and it's the incomplete aspect of that in the context of the guidance, which is child-centric, of course, that in our respectful submission means both at Home Office level and unfortunately before FTT, in the absence of the Home Office being present, and again the mother providing an account to the court. It's simply down to that account and nothing else. In other words, the shift of the burden and the duties and obligations upon the Home Office are pushed across, first of all, to the court, and then second of all, to the individual per se. And that's not to say an individual will not have to present their case and provide evidence that they can do, but this is someone in a second language from a different country coming before a court system, and of course, whether with or without legal advice and legal representation, in circumstances where the Home Office have trained officials to look for the very issues, identify the red flags, in circumstances involving children, and to work with other multi-agency bodies, as again enshrined within the Part 1 and Part 2 of the guidance. One, for example, if one considers a situation where did not arise in this case, my Lord, but in another instance, hypothetically, if other agencies had been involved, then there appears to be an obligation on the Home Office again to ensure that that information is provided in order to make an informed decision. One can think of, my Lady Chief Justice be more than familiar in the context of the family courts, of the obligations on state bodies where there is a concern about a child, about the positive obligations and the positive steps they take. And it's done. Similarly, in Part 1 of the guidance, we have a raft of other public authority bodies who are all in the realm of these very same types of obligations. And Section 11, subparagraph 4 of the Children Act does make reference to those bodies also having regard to similar guidance. Now, I have to say candidly, we could not locate the similar guidance, but certainly in the statutory functions they are to perform, the very same provisions, there is a mirror of 55.3 in terms of the UK Borders Act legislation in terms of Part 1, other state bodies. And of course it begs a rhetorical question. If the border agency feel that they do not have to comply with their statutory obligations, then that does raise a concern about the multitude of all other state agencies under Part 1 who hold similar responsibilities and have to discharge similar obligations. So this, again, in the context of Arturis, whilst looked at quite narrowly through the prism of wishes and feelings, and a very limited role for the border agency at the very outset and the very conclusion in the course of the removal of a family or a child, this has an effect in many more instances and across many more areas, all of which are common to ensuring the welfare and safeguard and promotion of the best interests of the child. So one cannot respectfully look at this merely in the context of immigration, because the ramifications of this extend across a broader spectrum of instances, at the heart of which will be the best interests of the child. So it's against that backdrop that, and again, I don't wish to trouble the court, the CAO decision in many ways speaks for itself, and between paragraphs 57 to 74, it sets out a number of issues and a number of aspects of Arturis that the court, the Northern Ireland Court of Appeal, seeks to address. And I respectfully ask and invite the court to consider those in its own time, but with particular emphasis on paragraphs 73 and 74, please, which essentially those are the suite of concerns elicited by the Court of Appeal. The next 3 points, I hope, are somewhat shorter points, and if the court permits me, first of all, the third point is the Section 55 relationship between rights and obligations, duties under 55 and Article 8 of the Convention. And Mr McLean yesterday was arguing in a way that Section 55 has been interpreted and implied as subsuming Article 8. Now, Lady Rose queried yesterday, if that was so, well, what role was Section 55 to play? Section 55 in its own right must have some meaning. And we respectfully agree with that. A friend seemed to suggest that all that really needs to be satisfied is Article 8. And what we say Section 55 does is that it properly perfects the procedural dimension of Article 8. In effect, the Article 8 protections, Article 8 is a floor, it's not a ceiling, and that the legislature is free to enact measures that can complement Article 8 in a manner to ensure the protections are practicable and effective. And that's all that's happening here. Simply, there's another statutory scheme here at Section 55 that reflects other international standards and which in essence work to perfect the Article 8 analysis. The fourth point is in relation to the issue of appeals before the FTT and UTT and judicial review. And Mr McLean yesterday noted that the reading he offers of Section 55 is it's not form over substance, that you can apply really in all cases in which Section 55 arises, the curative approach whereby the court can intervene, such as with the FTT, that it can discharge its functions through its powers, and that could also apply elsewhere. In other words, when one considers the role of the Judicial Review Court, which of course is in many ways applying different functions, different purposes, and we respectfully would say to the court that therefore, to try to equate one with the other, so that to suggest that a Judicial Review Court could perform an equivalent function of the FTT should be treated with circumspection, because our understanding of what was being suggested was there could be parity across the board, where again, if the Home Office have failed to discharge their obligations, and it ends up, for example, by 353 route before the Judicial Review Court, then it also can proactively take steps to cure the shortcomings. In other words, it seems that the Judicial Review Court should take on functions beyond those that normally, presently, it would. The Judicial Review Court, of course, is not a court of appeal. Not even in the context.
I think we discussed this yesterday, but just remind me what the answer is. The Section 14 in the 2007 Act preventing remittal to the Secretary of State. Does that apply to a judicial review, or the judicial review is just, it will just quash or uphold the original decision, presumably? How does that work?
I'm going to ask that Mr. Anthony just checks this, but I'm pretty sure that it stands outside of that scheme. Yeah, it stands outside that statutory scheme. So
judicial review is not affected by the Section 14 limitation on remedies.
no, Lily.
Well, indeed, the whole point of judicial review is if the decision maker has made an error of law, it's remitted back to the decision maker to take the decision again without an error of law.
Indeed, my lord.
That's the whole theory of judicial review.
Whereas what seems to be canvassed is, well, the Judicial Review Court could take on some form of curative role here also, as the FTT would do.
But I think you were also asked whether there's any equivalent to Section 31(2)A of the Senior Courts Act as to whether on a judicial review, if the court is satisfied that correcting the flaw would not have made any difference to the outcome, they can decline a remedy. Is that applicable in Northern Ireland as well?
I understand that Mr. McLean confirmed it was yesterday, and I
Right.
don't in any way demur from that.
Right. So, I mean, if one was going down the judicial review route, the focus would be the decision-making process by the Secretary of State. That's what distinguishes this position where you have an appeal to the FTT, where the FTT is doing its own decision-making function. But if you were going down the judicial review route, you would first ask whether the Secretary of State had failed to comply with some duty upon him. And then one would ask whether such error of law as had occurred was material in the relevant sense. It used to be a stricter test in the common law, and now we have Section 31(2)A of the Senior Courts Act. And so you'd have to ask that question, whether it's likely it would have made a difference.
Indeed, Lord, yes.
Okay.
But what the High Court, you say, would find it more difficult to do is to have the corrective approach of saying, well, we will look at this afresh and carry out our own best interests assessment, which might well result in the in overturning the negative decision of the Home Office in circumstances where on a judicial review that wouldn't practically be available to the High Court. They would have to send it back to the Secretary of State, yes.
For the ease of reference, Mr. Anthony reminds me, Mr. McLean may know the answer, the legislative provision does not extend to Northern Ireland, but perhaps my friend overnight can assist with what in fact the equivalent is.
Oh, right, that's what we're asking.
Yeah.
For some assistance.
31(2)A, right. Well, if that would be helpful, I think, for us to know where that comes from.
The final issue, if I may, point 5, is the issue of due regard versus regard. And essentially, Mr. McLean yesterday advanced, well, it's not the written case that the Section 55 regard term equates with due regard duties, for example, citing Section 149 of the Equality Act, Section 75 of the Northern Ireland Act. Again, we invite this court to treat, seeking to read one across into the other with circumspection. And my Lady Rose yesterday noted the term regard when this was first raised in Section 55 as opposed to due regard. On one interpretation, in fact, may be a more onerous obligation. And we would accept that. We, in fact, would advocate that that is the instance, that it narrows regard down and gives it, in fact, greater weight than due regard. And it is in the context, of course, as Section 55 is when we're dealing with discrete decisions around individuals and in circumstances particularly where we're dealing with children. And there should be no dilution, therefore, that we say of, in any shape or form, seeking to diminish what the responsibilities and duties actually are. And the case is the equality legislation, screening analysis in terms of equality or inequality of treatment between protected groups and so forth, is a very different type of case and very far removed from a Section 55 decision. And therefore, we do respectfully submit that regard ties up much more with anxious scrutiny and decision-making tailored to the specific circumstances of the child. And in some of the decisions referenced, HOTAC and Jewish rights, in short form, what we respectfully submit is this, that in a case involving children, as this court, as the international obligations, as domestic law makes very clear, whomsoever may be the decision-making body, they must get it right. We're dealing with children. And so, having regard to Section 55, bringing in extra scrutiny and ensuring that it is done properly in order that there is a proper basis for an informed decision being made at whatever level of the process, must always be seen where a primary consideration is the welfare of that child. For once, I may have astounded the Lady Chief Justice by finishing within the hour, but save for any questions or any further assistance I may provide to this court.
Thank you, Mr. Holland. We're very grateful.
Thank you.
Mr. McTiernan.
I'll focus on the issues between the parties as they've emerged from the reply. On the point we've just been on about judicial review and the elevated threshold, I think I touched on this yesterday, but it's right that the provision in the Senior Courts Act doesn't extend to Northern Ireland. It's England and Wales only. However, I also took you, I think, to the decision in JR 137, and the relevant section of it, just for your note, is in page 1268 to 1269 of the authorities bundle, where the judge discusses the practice in Northern Ireland to adopt the elevated threshold, or sometimes called the second-tier appeal criteria, in judicial reviews in this context.
Sorry, that's a different test. That's not what we're talking about when we're talking about Section 31(2)(a).
Yes.
Because that's looking at the remedy.
Yes.
The second appeal test is a restricted. It's a narrowing of your ability to get before the court in the first place. Then they're not the same thing.
I'd understood that to be the kind of cart elbow approach.
Yes. Yeah. So cart restricts the circumstances in which you can get to the court.
Yes.
Effectively, in a cart situation, it applies the second appeals test, and you have to be able to show that the case is particularly important before you even get leave.
Yes.
But once you're before a court, whether via that route or in an ordinary judicial review, and you as a claimant have established that there's been a breach of duty by the decision maker, there's then the question of remedy, and Section 31(2)(a) addresses whether you will get a remedy at the end of the day.
The position in Northern Ireland is similar, but it's a question of discretion, ultimately. So there's not a statutory requirement. The equivalent doesn't apply. The cart elbow approach applies at the leave stage in the same way, so it's an elevated threshold to get in. The question of whether or not a remedy is afforded is a matter of discretion at large for the court.
Right, so does that mean that in Northern Ireland, the Northern Ireland courts would apply the approach that was adopted in England and Wales before the addition of
Yes.
subsection 2A?
Yes. It may yield similar results, but we don't have the same statutory constraint that applies in the Senior Courts Act.
Yes, right, thank you.
So, in terms of judicial review as opposed to first-tier tribunal and the approach to be taken, we accept that there's a different approach in respect of judicial review. There's not an obligation on the Judicial Review Court to engage in any kind of inquisitorial function. It has a supervisory role only. It will examine qualitatively the nature of the decision and it will be open to that court to make a quashing order and remit. So we accept that is different from the position in respect of the tribunal dealing with a human rights type appeal. So it's probably my fault if I've suggested they're directly analogous. We accept that they're not. But this appeal and the issues that arise are relating to appeals, human rights appeals within the tribunal structure, not judicial reviews. So we're focusing on the system that applies where we have Section 55 issues arising in the context of a human rights appeal through the tribunal system.
The standard of compliance with Section 55 and the guidance must be the same, because the decision maker has no idea when they take the decision whether there's going to be a challenge at all, or whether it's going to be an appeal to the FTT and upwards, or whether it's going to be by way of judicial review.
Respectfully agree with that. And I think that when I answered the lady yesterday at the end of my submissions, that's what I was directing my response to. The arrangement should be the same. The content of the duty is the same, regardless of whether it falls to be considered in the FTT or in the judicial review. But how those differing tribunals deal with a challenge or a conflict about Section 55 differs. The Judicial Review Court will be constrained to look to the decision and analyse it. The tribunal can adopt its own role in respect of the decision-making process. And that's because one of the fundamental concepts in play here is that the tribunal, the FTT and indeed the UT, is an extension of the decision-making process. That's one of the cardinal features of the scheme. So,
well, is that not because the FTT has to ask itself various questions in looking at the rules, and in particular undertake the Article 8.2 balance? Because I wonder about that. I know some of the authorities refer to extension of decision-making role, but it cannot, arguably, I think, take away from the primary obligation on the Secretary of State to make the decision in accordance with the guidance. And I think what Mr Mulholland has raised in his argument is a potential immunisation or dilution of that obligation if you rely on the FTT to effectively do the work of the Secretary of State in some of these cases and scenarios.
well, the obligation remains on the Secretary of State.
Yeah.
It's not absolved.
No.
He or she's not absolved from that by the fact that there's an extended role for
No.
the FTT. And if the Secretary of State doesn't discharge a statutory function, he or she can be challenged by way of judicial review, and it's no answer that there's an extended role for the FTT. But if we're in a case that's before the tribunal, then the tribunal can deal with whatever the substantive issue is.
How does that work as well in terms of the limb of providing supports and services that Mr Mulholland raises, which is the broader picture here? If there's some message given in terms of how you adhere to this guidance at this decision-making frontline level?
Well, if there's I'm not sure what's really meant by the issue about these other services. All the other public authorities who are engaged with a child in this context are also subject to the same kinds of duties. Not a 55(3) duty, but a Section 11 Children Act duty, or in Northern Ireland it's under the Safeguarding Board 2011. So they have the same obligations. So if there's a shortfall in service provision, That's for the other agents to address and to answer for that shortfall, not for the UKBA to address it. So I don't see that a case falls between the stools just because we say the FTT has a responsibility in the decision-making role in this context. All the other agencies have their own responsibilities and can be challenged if they're not discharging them. So we don't really see that that's a fundamental problem. The judicial review role is more constrained. We accept that. However, both the FTT and any court dealing with these issues has to address a question about the content of the duty that's in play, and that's one of the issues that's between us. It's between the parties here, it's between the Court of Appeal and the upper tribunal, and that's one of the points in the debate. And one of the questions that has to be addressed is what is the actual content of the Section 55 duty? We say that question has to be answered by reference to what Parliament intended and requires a careful look at why the provision was enacted in the first place. And the Section 55 provision was enacted in order to level up the approach to the welfare of children, because prior to 2008, there was a derogation from the UNCRC for matters of asylum and immigration. When that reservation or derogation was removed, the Act was enacted to level up, so we had a level playing field across all the agencies. And we then had the equivalent provision. So the content of the duty then requires to be examined against that purpose in terms of Parliament, and by looking at what the provisions actually do. And this is where we say the Court of Appeal and at times the upper tribunal has taken the wrong path. We say the duty is a duty of means, not result. It was enacted to ensure greater awareness by decision makers and officials of the need to safeguard and promote the welfare of children. It's a duty to be exercised in substance. There's no prescription in the Act as to how it should be exercised. There's no enforcement mechanism. Contrast, for example, things like Section 75 of the Northern Ireland Act, which has a particular enforcement mechanism in terms of a default. It didn't mandate the enactment of guidance, but where the Secretary of State elected to have it, then there was an obligation to have regard to it. Standard public law principle, nothing unique or contentious about that. The guidance itself operates at a high level of generality. It isn't prescriptive. There is occasional use of mandatory language, but even then, bullet point 4, paragraph 2.7, there are caveats and qualifications in respect of that. And the weight to be given to the guidance, we say, is a matter for the decision making.
But are you saying that really, whether it's by JR or whether it's in the tribunal, the right question to be asked is not so much was the duty under Section 55(1) and or 3 complied with, but does this decision respect the child's Article 8 rights?
Exactly. Has appropriate regard been had to the Article 8 rights of the child? And that's a question which you would be answering anyway, even if Section 55 had never been enacted. Because you, the decision maker, the public law.
So the point of Section 55 is to try and make sure that in more cases Article 8 is properly assessed? Yes,
and it was a levelling up to ensure that the reach of the Section 11 2004 Act provision stretched across to those involved in asylum and immigration. Now, why did they simply not amend Section 11 of the 2004 Act to add UKBA? Well, that's because there are different devolved jurisdictions with different statutory schemes. So it was done through one Act which had a UK-wide reach. So that's why.
The Article 8 rights applied even when there was that derogation.
Anyway, yes.
From the UN Convention on the Rights of the Child. But do you say that the content of the Article 8 right of the child was changed when the derogation was removed?
No, the content didn't change, but what Parliament did was enacted the provision to ensure that it was clear that all public authorities engaged in this area had the same obligation to have regard to the promotion of the welfare of children. So it's against that backdrop that we look to the content of the duty. What is the duty? And it is, I've said yesterday, and I won't labour the point again, it is analogous to the other due regard duties that we have, for example, the public sector equality duty. And I have said, and I maintain today, that the interpretation is placed on, for example, public sector equality duties in terms of their content is readily applicable in this context too. Contrast that with what the Northern Ireland Court of Appeal and the Upper Tribunal in MK and JO have considered to be the content of the duty. The view of the Court of Appeal is that it will be a fundamental error of law if it cannot be discerned from the decision letters that the guidance has been taken into account. This has been elevated to the status of an absolute and mandatory requirement. You can take that from paragraphs 16 and 18 of the decision in EFE. I opened to you yesterday. The reference again is page 1409. That's expressly adopted by the Court of Appeal at paragraph 21 of the judgment in JG, which is the operative Court of Appeal judgment here, really. And you'll find that at page 1232.
1432.
1232. This is paragraph 21, JG. And at paragraph 35, that's at page 1235. Again, I showed that.
Paragraph 35.
Paragraph 35, Lord, yes.
Page
1235.
Thank you.
So, our Court of Appeal have interpreted this open-textured duty linked to the guidance as something that has absolute and mandatory requirements. And that's, again, evidenced by the interpretation put on the Court of Appeal's analysis by another one of our High Court judges, Mr. Justice Schofield, in JR 137. I took you to that yesterday. And he there interprets this as giving rise to critical absolute minimum requirements, which, if not met, give rise to the same kind of error of law, even where he also accepts the best interests of the child have been fully considered. So there's a difference, a fundamental difference in the content of the duty between what I say Parliament sought to enact and what our Court of Appeal have interpreted it to mean. And that requires reconciliation. And when you analyse the point that way, we say that that answers one of the potent rhetorical points which my learned friend makes, which is echoing our Court of Appeal. He will say, look, the court's repeatedly saying, you never comply with this. There's no example of you having complied with this. And our Court of Appeal say that in JG, over a decade, this hasn't been complied with. But the rhetorical force of that point depends on what the content of the duty is. Because the view of the Home Secretary is, there has been compliance. You have misunderstood, over-interpreted, and over-elaborated the nature of the duty. So, the Court of Appeal, we say, have imposed too exacting a standard and then have diagnosed that it has never been met. But if that's the wrong standard, then that point melts away.
Well, I must say, I don't really understand some of that submission in terms of the nature of the duty. I mean, is the nature of the duty not self-evident from the guidance which informs Section 55(1)? I mean,
Yes.
You can't rewrite the duty that is on the Secretary of State in relation to how you deal with children who are part of this immigration area, in terms of the points we've been discussing. Consultation, taking into account wishes and feelings, every child matters and such like. I mean, are you saying that the duty is perhaps a lesser duty in substance than courts have thought it has been to do?
Lesser than our Court of Appeal have considered it to be. But
on
exactly.
what basis do you rewrite? I'm talking about the substance of the duty.
Well, I say that the upper tribunal in Arturis have interpreted the guidance in a manner that aligns with the submission that I'm making. There's a difference between those two bodies. I'm not suggesting there's a need to rewrite the guidance. There's a need to interpret it properly. And when one looks to the guidance, for example, take the high point, which is 2.7 and bullet point 4, where there's talk of engaging with the child to ascertain their wishes and feelings. Yeah. Caveat, where practicable. Qualification, where there's a parent first, they may be able to convey exactly what that is. So it isn't a mandatory, absolute, critical requirement. It's subject to qualifications. So we say what our Court of Appeal has done has elevated the standard on their reading of what the guidance means, and I'm contending for a reading of the guidance aligning with what the upper tribunal have said in Arturis, aligning with Court of Appeal in AJ India, and we say that yields the correct answer. And that answer is...
And what about the Scottish cases?
ZG, yes. The ZG decision also aligns with the analysis we're putting forward.
But surely the application of the guidance is fact sensitive. That's really what all of these cases should come down to. Yes. The guidance itself, in terms of informing the duty, doesn't change, but the outcome depends on the facts of a particular case.
The weight to be given to the duty is a matter for the decision maker. That will be, again, I accept, fact sensitive. That doesn't really change the content of the duty. No. But we say that our Court of Appeal have created and elevated too high a threshold, and then, unsurprisingly, identified that it hasn't been met.
But I think you also say they've uncoupled it from the Article 8 analysis.
They have. And we say the other answer to this is actually the issue is addressed in substance by a proper analysis of the Article 8 obligation.
I mean, in this actual case, do you say that what Judge Rintoul, I think it was, did in the upper tribunal was the correct approach and the Court of Appeal was wrong to identify any error of law in his approach?
Yes, we say, going back one step, we say in the first tier tribunal, Judge Grimes took the correct approach. She looked to the case through the prism of Section 55. Then at the end of the judgment, it's paragraph 53, I'm sure I won't be able to find the page number right now, but yes, it's page 719. You will see that she then did a freestanding Article 8 analysis. She checked with the representatives, the legal representatives, whether there was anything additional in respect of Section 55 and Article 8. They said it's essentially the same case, and she conducted the Article 8 analysis there anyway. So, entirely correct approach. Judge Rintoul looks at that, finds no flaw, and the Court of Appeal take a different view. But we say the original FTT decision was sound, properly balanced both issues. Certainly the focus was on Section 55, but the first tier tribunal also looked at Article 8. And that brings me to a second fundamental difference, I think, between the parties and between the Secretary of State and the Court of Appeal, which goes to the consequence of a diagnosed breach of Section 55. So, again, parliamentary intention. Section 55 gives us no particular steer because, unsurprisingly, it's a kind of due regard duty and doesn't have an enforcement mechanism. The Supreme Court in ZH, in our submission, in paragraph 24, set off on slightly the wrong path. And I showed you yesterday, just for reference again, that's in the ZH decision of paragraph 24, in Lady Hale's judgment, it was extrapolated from a concession of sorts that a failure to address Section 55 would have the result the decision was not in accordance with the law, with the consequence it fails a legality test and would have to essentially be quashed. We say that's an incorrect analysis for the reasons I went through yesterday. The upper tribunal in Arturis agree with that, and the reference is paragraphs 115 and 116 of Arturis. That's page 1113. But this idea that a breach of the Section 55 duty leads to a legality problem, a failure in accordance with law, has had enduring effect. You see it emerging again and again in the decisions. And it has led to a view and to arguments that a breach of the Section 55(3) duty, as interpreted by our courts, i.e. not identifying the duty or the guidance in the decision making, a breach of that nature is an unremediable error of law, which should lead to remittal, either to the Secretary of State prior to 2014 or to the tribunals thereafter. And we say that's a problematic approach. And again, this takes us into, with respect to the human rights type claims, the actual arrangements for the first tier tribunal. Now, I've made the point already that it's the first tier tribunal is an extension of the original decision making process. Reference Lord Doherty in ZG, he makes that very clear. Where there's a procedural error in the decision making process, it can be corrected in the appeal. So that's the fundamental difference with judicial review. You can correct the problem in the appeal, and that's what the Court of Appeal said in AJ India back in 2011. Third point that shouldn't be overlooked is that in these kinds of human rights appeals, the burden of showing removal would be in breach of Article 8, rests on the appellant. So it's for CAO, in this case, to put all the evidence she wishes to put before the first tier tribunal, including evidence about the wishes and feelings of the child, if that's considered to be relevant. And that can be done in a range of ways. She was legally represented here. She swore a witness statement. She gave evidence orally before the tribunal in English. And more could have been done. And if the tribunal was concerned that there was a gap or lacuna or something had been emerged, or a red flag, as Lady Lead Chief Justice puts it, then the tribunal could say, well, actually I have powers under the rules to seek more information. I've actually got powers under the rules to engage with third parties, other public authorities, and seek information from them. And by that route, the issues can be fulsomely and wholly addressed.
And that still results in an appeal being a better route for a claimant, because if it can be corrected in their favour, then it will be without having to go back down to the Secretary of State. But if the FTT corrects the flaw but still refuses or still says that the person needs to be deported, the claimant has in a way foregone the opportunity of a fresh decision by the, I don't mean that in the technical sense, but of a reconsideration by the Secretary of State.
Yes.
But
well, they have appeal rights within the scheme that they're in through the FTT. They can seek to take the matter up so that it's not the end of the road from a claimant's perspective. So in terms of the substance and the concerns about corrective approaches and the need for discipline in the processes, all of that can be achieved through the FTT arrangements, we say. And there's no detriment to the applicant in that context. Much has been made of the fact that at the hearing in this case, the respondent, the representative of the Home Secretary didn't attend. There's an explanation for that actually in the judgment itself. It's paragraph 3, page 709. This is February 2020, and the presenting officer was taken unwell just before the hearing. That's recorded, but it's not a point that goes anywhere anyway. And we say it's because The facility was available for CAO to provide whatever information she wanted about the child, the risks of genital mutilation, the best interests of the child. The fact that the Home Office representative wasn't there means that that stood unchallenged. That's not a negative point for the appellant, that's a positive point. And it actually, the upper tribunal in Arturis notes that, and not about this case, but generally speaking, where there's a facility for evidence to be provided and it's not challenged by the Home Office, it stands for the tribunal to evaluate. But the net result of all of that is, in this case, the tribunal had all the evidence that the mother wanted to put forward. It also had the facility to pursue lines of inquiry if itself it considered there was a best interest of the child problem. And underpinning that, again, is the fact that the tribunal has an obligation under Section 6 of the Human Rights Act itself, in a case of this nature, to consider the best interest of the child. And that's why I've pointed you back to paragraph 53 of the FTT judgment, Judge Grimes cross-checking, as she should. I've heard Section 55. Is there anything else in Article 8 I need to consider? And she considers it and says that doesn't add anything to the overall mix. So we say that where there is an argument that there's been a breach of Section 55, guidance isn't being referenced, we say that doesn't and shouldn't give rise to hard-edged findings of an error of law, quashing or remittal. It's something that can be addressed within the tribunal process and system itself, and that's what Parliament intended. And that's been underscored by the fact that in October 2014, Parliament removed the provision to remit to the Secretary of State, deliberately done, to ensure that these issues were resolved internally to the courts and tribunal processes at whatever tier. And on the same day that the amendment was made to the 2002 Act, the expanded 2014 rules took effect. So, seamlessly dovetailing, expanding the powers of the tribunal at that juncture. All of that, we say, points against the approach that our Court of Appeal has.
But in this case, in paragraph 81 of the Court of Appeal's judgment, they say the failure of the officials to have regard to the statutory guidance in breach of their duty is both uncontested and incontestable. So is that correct? The Secretary of State did accept. The Secretary of State accepted before the Court of Appeal that there had been a breach of the duty under Section 55(3).
Well, I'm not sure about that. I think how I would interpret that is a breach of the duty as defined by the Northern Ireland Court of Appeal, i.e. the elevated duty. Was there a reference in the decision letters to Section 55(3) and the guidance? So that's the Northern Ireland Court of Appeal's interpretation of what the duty involves. And if that's the question, the answer was there isn't a reference to those things. So if that's what you say the standard is, Court, it wasn't met. But the submission I make here is that that's a misinterpretation of what the duty actually requires.
But suppose the situation was that the decision maker says, I mean, I think there's been one case where they weren't aware that there was a child present. But if there is an admitted breach of the duty to have regard to the guidance, someone had missed the training or whatever, didn't know there was a guidance, how do you remedy that? Or do you still say it doesn't matter as long as they actually did a compliant Article 8 assessment?
I say it doesn't matter ultimately, because the overall duty is one of substance. The substance is, have you had regard to the need to promote and safeguard the welfare of the child. If you've done the Article 8 analysis correctly, then you will have done that anyway. So I say it doesn't necessarily make a difference there. But you can see, and it's quite useful to look at what the court's been saying in the paragraph you've alluded to. That's seen as a frank breach, and that frank breach requires remedy, and then the Court of Appeal gets into a discussion about what the remedy should ultimately be.
But you would, so is your case that in every situation, the tribunal or the judicial review court has to go on and assess the adequacy of the Article 8 analysis?
The tribunal certainly does have to.
Right. And that may well be informed by an acknowledgement that there wasn't the correct Section 55
let's say, to concretise the issue, let's say the views taken that the wishes and feelings of the child weren't taken into account, that there wasn't, the trained UKB official missed that point,
yeah,
and the tribunal identifies that. Well, the answer to that is you have powers to say, can someone, whether it's UKBA, a social worker, the mother, provide me with a witness statement on the wishes and feelings of the child on this particular issue so I'm fully informed in the decision. That's the answer to that. It's something that can be catered for within the system.
Or could you, within the system, decide as a judge at the first tier tribunal that the Article 8 proportionality exercise is against the Secretary of State because there's a missing material element in relation to best interests in a particular case? So you win your case at that stage then, and that, if you're an appellant? Where
that goes, I mean, the lady quite rightly raises issues about, you know, the disciplining of the decision makers and the disciplining of the officials and making sure the system works properly. If appeals are being lost because fundamental points are not being addressed, well, that has the same kind of disciplining effect. That makes the system work.
Yeah.
And again, when I go back to what I said, what's Section 55 about? It's about ensuring that people have to the forefront of their minds the need to have regard to the welfare and safeguarding of children. So that result's achieved, we say, on that approach. And if you, well, I no doubt the court will go back and look at ZG again, Lord Doherty's analysis. That's pretty much what the Inner House of Session were saying in ZG, and it's what the Upper Tribunal are saying in Arturis. And the difficulty we have is in the Northern Ireland courts, we have two high-level Court of Appeal decisions taking a different approach, and that means first-tier tribunal decisions will be bound by that, and the judicial reviews will also be addressed on the same basis. Concessions are made that wouldn't be made in Wales. There is still an issue about remittals and remittals by proxy, and it's been debated with my learned friend, and he's given an answer, but I think this notion of remittal by proxy is problematic. I mean, remittal means going back to the Secretary of State for decision making, and that's what Parliament said can't be happening. So that's not an option. Whether we call it remittal by proxy or something else, that's not correct. It is now recognised, I think, by the Court of Appeal that that's a closed door. The judgment in CAO is, I can see why my learned friend took this approach initially. Paragraph 44, which we've all looked at, recites in extenso the MK decision from paragraphs 36 to 39, and then says the passages reproduced above require no elaboration. Which would lead one to think that's actually endorsing the position. However, paragraph 62, and Lord Jones made this point yesterday, makes it fairly clear. There's a reference again to JG, refers back to paragraph 44. And then says, as the relevant passages in MKC are make abundantly clear, one key element of the debate was that having regard to the statutory arrangements then prevailing was one of the options available to the relevant tribunal, was in the event of finding a breach of either Section 55, an order the effect whereof would require the Secretary of State to make a fresh decision, undertaking the necessary assessment can be made. And then says, however, with effect from April 2015 at latest, and by virtue of statutory reform, this was no longer possible. So the Court of Appeal is saying, despite what's said in 44, what might be interpreted out of that this is not an option. And you will have seen why this has lingered around as a concept is in MK and in the JG decision in the Northern Ireland Court of Appeal, the court left floating the idea that there might be some way of actually quashing decisions and remitting them back to the Secretary of State. And that ambiguity persists, I think, until we really drill down and read paragraph 62 of the Court of Appeal clearly. And the Court of Appeal here is accepting that that's not an option. So the language of remittal and remittal by proxy, we say, is to be avoided. That said, I accept that where the first-tier tribunal is involved, one of the things that the tribunal is empowered to do is ask third parties, including the Home Office, to make inquiries and provide information. That's not a remittal. That's a discharge of the case management powers.
And then the FTT will take the decision.
Exactly. And again, that's in alignment with the statutory reforms made in 2014.
But can the FTT just set aside the decision?
Of the Home Secretary?
Yeah.
But it either allows the appeal or doesn't allow the appeal. That's the option.
But if it allows the appeal, right, then the decision is quashed effectively.
Well, it'll be a human rights claim. The removal can't take place because Article 8 will be breached, and there's no need to technically interfere with the decision of the Home Secretary. The Article 8 analysis at that stage of the process is removal can't take place. So
the removal can't take place.
No. If the Article 8 claim is made good, depending on the nature of the case and all of the caveats around that.
And that would be a binding decision on Article 8 by a relevant court. It would then be raised judicata between the parties that removal could not take place.
That's exactly right. That's the end of the matter. So, but it is important to keep these concepts doctrinally separate because there has been an unfortunate blending of judicial review remedies and tribunal remedies and appeals. We are now, in this case, dealing with appeals through the FTT arrangements, not judicial reviews. And the language of remittal is alien to this process now. That's not remittal to the Secretary of State. The Court of Appeal can remit to the first-tier tribunal, which it did in this case, and there's nothing improper about that.
I mean, it is, to my mind, slightly curious that MK, as I understand it, was a decision reached after the 2014 reforms had come in. But paragraph 38 does seem to be looking to the possibility of a remittal to the Secretary of State.
And that's the curious thing.
There it is. Yeah.
If you look at paragraph 62 of the judgment of the Court of Appeal, you'll see, again, some lingering doubt about that because it says, however, with effect from April 2015 at latest, this was no longer possible. And the MK decision was given in March 2015. But actually, from October 2014, it was no longer possible. So, as I read it, and the chronology, maybe other reasons why the judgments are dated in the way that they're dated, I don't know, but it looks like when MK was promulgated, it was after October 2014, and it wasn't an option.
Yeah, that's the curiosity that I was mentioning.
So then, but the FTT's decision is going to be either the Secretary of State was correct and there is no Article 8 right, in which case the removal can take place, or the Secretary of State was wrong and the Article 8 right is made out, and therefore there cannot be a removal either on the basis of that decision or any future decision. But is there a third option, which would be the appropriate remedy for a breach of Section 55, which is there's been a procedural flaw in the taking of the Article 8 decision, in the taking of the removal decision or the assessment of Article 8. So the removal cannot take place on the basis of that decision, but not finding that the Article 8 right actually exists, but leaving it to the Secretary of State to retake the decision, which might go either way. Or is that not what happens?
It begins to sound very much like remittal.
Well, that's what I thought that they were talking about, that the FTT could effectively allow the appeal, but not on the basis that there is an Article 8 right, but on the basis that the decision maker had not properly assessed whether there's an Article 8 right. But I think what you're, and that might be because there was a breach of the Section 55 duty.
Yeah.
But I'm hearing maybe that you don't think there's that third way.
I don't think there is that, and I think it's possibly unhelpful to hold out the possibility of the third way. The clearer approach is if you are identifying a procedural failing in this kind of case, it will be that there's an aspect of the best interest of the child that haven't been properly assessed, and if you're the tribunal,
You have to assess that.
you assess it and you ask for information. You call the mother back or whatever course you take. So it's, I think, potentially unhelpful to suggest there's a third way where you go back to the Secretary of State on these points, because that abrades with the intention of Parliament in the repeal of
But there would
Section
have to be that third way if Section 55 was this kind of freestanding procedural aspect.
Yes. Well, I would play the point in my favour, I suppose, that when we look at the scheme as a whole and how it's meant to work, the fact that there isn't a third way supports the view that Section 55.3 doesn't have the elevated, complicated, particularised nature that the Court of Appeal has found. And it was never intended to have that. But it has acquired it through a process of judicial interpretation, which doesn't really find foundation in Section 55 itself.
But I think it deserves stressing that the FTT has its own obligation to ensure that the best interests of the child are taken into account, and its own obligation to make the Article 8 assessment.
Exactly, regardless of the case being made or however it's being presented.
And that is different from the High Court on a judicial review.
Yes, it is.
Yeah.
So it is clear that there are still significant points of difference between the appellant and respondent in this case and between the Northern Ireland Court of Appeal, the upper tribunal, and other. There is a significant issue to be addressed. There is no doubt of that. And I trust in the submissions we've made, we've advanced a possible resolution to it, but it's a matter that we say requires reconciliation by this court. Ladies and Lords, those are our points in reply at this stage. I know we finished a little early, but that's...
Lady Rose and I would both like to know the actual position in relation to Section 31(2)(a).
Does it apply or not?
You've told us it doesn't apply.
Yes.
Could it be checked that there isn't a Northern Ireland equivalent? And I think I put to you, if there isn't, you accepted that then we're just left with what used to be the old position in England and Wales as a matter of discretion, which is rather tighter. In fact, the case I have in my mind is simplex. You basically, relief will only not be granted in the discretion of the court if it can be seen that the outcome would inevitably have been the same, which is rather different from Section 31(2)(a). But at all events,
yes, I think either to know that Section 31(2)(a) does or doesn't apply, or if it doesn't, has actually the case law in Northern Ireland got to effectively the same position, or is it still in the
It definitely doesn't apply, but what I suggest we do is, within a short period of time, agree a joint note on the issue, no more than 2 pages.
David, I think
Yes, I think that would be very helpful.
that would be helpful. As I say, dredging my memory from the position prior to the amendment of the Act, simplex was the case that I always used to have in mind as setting out what the test was, and it's quite a strict test. But I don't know what the Northern Ireland authorities would be on that.
Well, we'll have that addressed within 7 days.
7 days would be fine. Thank you very much.
Thank you.
Anything further? No? Well, Mr. McLean and Mr. Mulholland, we're very grateful to you and to Mr. Henry, Mr. Anthony, Mr. Peters for the submissions, both orally and in writing. And we're also very grateful to those sitting behind you for the preparation of the case, which is much appreciated. And we will take time to consider our decision in the matter. The court's now adjourned. Thank you all very much.